Happy day. I am Krupa and Assistant Professor, Department of Management Studies, BBA Shift 2. My topic is going to be on the subject Business Regulatory Frameworks, and my topic is going to be offer and acceptance, that is essential elements of offer and acceptance under the chapter Indian Contract Act 1872. What do you mean by an offer? According to section 2 subsection A of the Indian Contract Act 1872, a person is said to have made the proposal when he signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that offer to such act or abstinence. In short, the definition states that any person who is willing to offer something and any person who is willing to accept something is called as an offer and the acceptance. Let's get into in detail about how can you make an offer, how to make an offer. The offer consists of two types. One is the express offer, second one is the implied offer. What do you mean by an express offer? An express offer is one which is made by words spoken or written, which is expressed to another person. Example, X says to Y, will you purchase my car for 1 lakh? Here, you have two parties to contract. You have a consideration in written which is coming under the Indian Contract Act. So when X says to Y that whether he want to purchase his car for 1 lakh, there are two parties involved. X will be the offerer and Y will be the acceptor. That is, X wanted to offer something and Y wanted to accept something in the consideration of 1 lakh. This is called as an express offer. Second one is called as an implied offer. What do you mean by an implied offer? Implied offer is one which is made otherwise than in words. In short, an implied verse is something which will be accepted or it is inferred from the conduct of the parties. We'll just understand this with a case law and with an example. For an implied offer, a bid at an auction is an implied offer to buy. So now let's come to whom an offer is made. The offer can be made by specific or the offer can be made as a general. What do you mean by a specific offer? A specific offer is one which is made to a definite person. Definite person, example, X is offering to Y. X is offering to Z. So there is a specific person which is between two parties, X and Y, X and Z. That is a definite person. That is called as a specific person. Next is called as a general offer. A general offer is one which is made to the world. A general offer is one which is made to the world at large or public in general. We will understand this general offer with this case law which is called as a Carlyle versus Carbolic Smoke Ball. Carlick is the person who has been affected. Carlick Smoke Ball is a company. So Carlick is filing a suit against the company of Carbolic Smoke Ball. So I am just explaining about the overview, the purview of what is the case. Carbolic Smoke Ball has introduced a rubber ball, a smoke ball to the world, and they have advertised in the newspaper telling that whoever is consuming this smoke ball, the person who is consuming the smoke ball will not be affected with influenza, will not be affected with any cold, cannot be affected with wheezing or fever. This was a statement which was being told by the Carbolic Smoke Ball and Company, and they had advertised that in the newspaper. So as one of the reader, Miss Carl, when she was come across the advertisement in the newspaper, and she thought that maybe if I am going to consume this smoke ball, I can like overcome my cold or fever, and I will be better if I am going to intake this smoke ball. And Mrs. Carlick wanted, and she had also taken this smoke ball. But after taking the smoke ball, Miss Carlick has contracted with an influenza, maybe a cold or a flu. So Ms. Carlick had stated she has filed a case against Carbolic Smoke Ball Company telling that you have given an advertisement in the paper that whoever is going to consume the smoke ball is not going to get affected with the cold or the flu, but in my case I have been contracted with this disease or with this virus called influenza. So she needs some kind of an compensation from the Carbolic Smoke Ball Company. When the judge was hearing the arguments between Miss Carlyle and the Carbolic Smoke Ball, the judge gave the judgment against the Carbolic and for Miss Carlile. So what was the judgment? Carbolic was claiming that they didn't know that Miss Carlile was consuming the smoke ball, and in what way Carlile was consuming the smoke ball, whether she had followed the conditions of the Carbolic smoke ball. But the judge has clearly stated and given an argument in the judgment in the favor of Carlile, telling that it is a general offer. Number one, Carlile is one among the 2 million population who has accepted the offer. So it's a general offer, and it's not that Carlile need to go back to the company and inform them that she is consuming their smoke ball. So in this case, whatever they have given an offer, whatever they have given in an advertisement, they were not to it, and the judgment has been in the favor of Miss Carlile, telling that Carbolic smoke ball have to pay the compensation for Miss Carlile. So this is for the example of general offer. Next, we are going to see about what are the legal rules of the valid offer. Essential elements of the valid offer. The first one is intention to create a legal relationship. If you take any kind of an agreement, you can classify that agreement into social agreement and a legal agreement. So what do you mean by a social agreement? Social agreement is you are promising your friend that you will be attending her birthday party in evening. You are promising your mom that you are going to keep your room clean. These are kind of a social agreement which is not entering into a legal agreement. Suppose if there is any legal suit between a husband and wife, the husband has filed a divorce against the wife, then they are entering a legal relationship. So that is called as an offer must intend. The offer, the X and the Y should have an legal agreement entered into it. That is called as the offer must intend to create a legal relationship among the parties. Second one is certain and unambiguous terms. So what do you mean by certain terms? What do you mean by not vague terms? Both the offer and the acceptor should be very clear in what they are stating in an agreement. Only then the agreement can be enforceable by law. So if X is offering, or when X is giving a statement which is not very clear, which is very vague, then it will not come under the essential elements of an offer. So here I have given you an example for that. X offers to sell to Y 100 tons of oil. So this person X, he is not a dealer of one oil. He is a dealer of both coconut oil and he is a dealer of mustard oil. But what kind of statement he has given? X offers to sell to Y 100 tons of oil. So here it is involved with the vague term. The person, the X, need to be very clear in what type of oil is offering to sell. Whether he is selling the coconut oil or whether he is offering the mustard oil. Next is different from the mere declaration of intention. Just like that giving a promise, or just like that speaking to another person, or just like that giving a statement will not be coming under the essential elements of offer. The offer must be distinguished from a mere declaration of the intention. Both of the parties should have an intention to enter into a legal agreement. So just the declaration will not come under the agreement, or will not be forming an agreement, will not be coming under the essential elements of an offer. So X tells Y, I want to sell my car for 1 lakh. It is just a mere statement of intention and not an offer. He is planning to sell a car, but in no way here the statement says, Mr. X says that he is selling his car on this date, or Y wanted to purchase his car. It is just a kind of a statement where both are discussing that the person is planning to sell his car. To whom he wanted to sell, whether he wanted to sell to Y, his intention has not been given here. Next is different from an invitation to offer. An offer must be distinguished from an invitation to an offer. So here X asks Y, at what price will you buy my car? For that, Y has replied that I agreed to buy your car for 1 lakh. This is also just a statement. X statement is he is merely inviting Mr. Y to buy his car, and Y is replying is merely he is giving an offer to buy. Next is a communication. An offer must be communicated to a person to whom it is made. Whether it is going to be an X who is the offerer, or whether it is going to be Y who is the acceptor, anything, it should be between only this X or Y. It should be only between this X and Y, and not a third party and not a Z. The communication have to be given only to the concerned party. So for this we have a case law here, which is Lalman Shukla versus Gauri Dutt. So Lalman Shukla is the servant and Gauri Dutt is employing Mr. Lalman Shukla, and Gauri Dutt was enjoying holidays with his nephew Mr. L, and L was lost and his nephew was lost, G's nephew was lost, and he wanted his servant to go out in search of his nephew and bring him down. And the servant was very happy because he is doing a favor for his master. So he went out, he found his nephew, and when Gauri saw his nephew, they were very happy. But when the servant has gone out, Gauri has given a statement that whoever is finding his nephew will be rewarded for some 500 pounds. But this was not aware for Mr. Lalman. So when Lalman came, bringing his nephew, Gauri has paid him just some 20 rupees or 100 rupees, and Lalman thought it's just a small reward from his master, and he was so happy with it. But later on he realized that there was an advertisement in the newspaper rewarding for some 500 pounds, and he realized that he was not being paid for that. So Mr. Lalman Shukla was angry and he filed a case against his master. So when the judge was hearing the case between Gauri and Lalman Shukla, the question which judge has given to Mr. Lalman was whether he was aware of the offer. When he was not aware of the offer, here the Lalman is not giving his acceptance to the offer. So when he is not at all aware of the offer, Lalman is not eligible to take that reward of 500, and the judge has given the judgment against the Lalman and for Gauri Dutt, because the offer itself was not being aware by the Lalman, and there is no statement here of Lalman knowing the offer and accepting it. No term the non-compliance of which amounts to acceptance. So there should not be any kind of non-compliance in the statement. So Feltos versus Binley, X writes a letter to Y. I offer to sell my house for rupees 1 lakh. If I do not receive a reply by next Friday, I shall assume that you have accepted the offer. Y does not reply, but here, since Y does not reply, the person X cannot take it into account that the offer has been accepted. Y did not reply, it can be any reason why he did not reply. So he can't take this for a grant. So there is no contract since acceptance was not communicated by Y to Z, Y to X. That is, Y should have expressly given his communication, or Y should have given us in writing, or Y should have called him and told, but silence will not be considered as an acceptance. Next is communication of special terms or standard form of contracts. The special term of the offer must be communicated along with the offer. So here we have a case law, Henderson versus Stevenson. Basically, what do you mean by in standard form of contracts or special contracts? Contract with the railway company, contract with an insurance company are the best example of the special contracts or the special terms in the standard contracts. So here the X purchased a steamer ticket with undisclosed liability clauses. Whenever we enter into this special contracts with a railway company, they will be having some hidden conditions regarding our luggage or regarding our baggage, where they are not informing us very clearly. They keep it in a very hidden way. So in that way, Mr. X has lost his luggage, and due to the company's negligence. But this was not being aware of the X. When there was a case between these two, the judge, the court have clearly asked them whether the conditions have been informed to Mr. X. When the conditions have not been clearly stated in the tickets, or when the conditions have not been clearly stated to Mr. X, then the company have to bear the loss. The company have to pay the compensation to Mr. X for whatever luggages he has lost, because due to the company's negligence, the company have not given the facts, the company were not transparent. In the case, the company need to pay the compensation to Mr. X. Next, a small topic, which is so far we are seeing about legal rules of the offer, and this is just a small, so when we are talking about all the legal rules of offer, we are talking even about another person who is called as an acceptor. So what are the legal rules for the acceptance? So according to the Act, the legal rules of the valid acceptance will be, it should be absolute and unqualified. That is, absolute meaning there should not be any discontinuance of the statement, and it should be free without any condition. When X is offering something and Y is accepting something, they have to accept in the same way what X is offered. When the car is being sold for 1 lakh, why have to accept it only for that 1 lakh, and why should not ask that he want the car for 1,90,000 or 80,000, which is called as a counter offer where he is laying a condition to it. So that is not called as an acceptance. So it should be absolute, and the condition, it should not have any condition. It should be free from condition. Second one is the manner. When the proposal describes, when the proposal prescribes the manner in which it has to be accepted, it has to be accepted only in that prescribed manner. The acceptance have to be given through telegram, the acceptance have to be given in writing, the acceptance have to be given in an oral mode, then the acceptance have to be only in the prescribed mode of a telegram or a letter or a call. When they are deviating from it, then they are not coming under the essential elements of an acceptance. The communication have to be given properly. The acceptance must be signified and communicated to the offerer by the acceptor only, and no third person can be involved in it. There cannot be any stranger to a contract. By whom? To whoever person it was, the same person need to accept it. And what is the time limit? The acceptance cannot be given whenever he wanted to give. When there is a time period of 3 days, they have to strictly follow the time limit, and they have to be stick on to their time. Whenever they are doing it over and above the time, the offer comes to an end. So the acceptance have to be given before the lapse of the offer. The acceptance must be given before the offer lapses or it is withdrawn. For the example, X offered by a letter to sell his car for 1 lakh. Subsequently, X withdraws offer by a telegram which is duly received by X after the receipt of telegram. Y sent his acceptance to X. In this case, the acceptance is invalid because it is made after the effective withdrawal of the offer. When the offer is elapsed, when the offer is over, you cannot make an acceptance to it. In that case, it will not be accepted. Mode of the acceptance. Acceptance may be given by the performance. It has to be given. They have to satisfy the condition. In that way only they have to give the acceptance. So just a quick thing. We started with an Contract Act of 1872. I explained you about what you mean by an offer, types of offer, then essential elements of offer, what do you mean by acceptance, and essential elements of acceptance. Thank you.